Hello, hello. Welcome to CashFlow Hacks. I'm your host, Chris, and with me today is my co-host, Stephanie.
Hello, hello. I'm so happy to be here with everyone else who's ready to make more, save more, and start living more now.
You're in the right place if that's you. Every couple of weeks, Stephanie and I are going to be discussing different tips and strategies or, just keep you in the loop with different topics that your financial advisor doesn't want you to know about. And why are we going to do this? Because the less you know, the more they make, and we want to help you flip that script. Stephanie, this week we're going to be talking about estate planning. You and I are always talking about this, and a lot of people think that having an estate plan is only for the wealthy. Can you start out and let the listeners know why that is not really the case?
Absolutely. So yeah, you're right. People think that way, but estate planning it's just a collection of legal documents, and it protects you through the different, I call them the 3 different stages of your life, right? When you're building wealth, stage 1, then when you're utilizing your wealth, stage 2, and then stage 3 is you pass your wealth on to the next generation. And so no matter what stage you're in, estate planning is for you. Now, what does it really mean? Well, like I said, it's the collection of documents. So what documents are included? Well, you've got your will, your living will, your healthcare proxy or durable medical or healthcare power of attorney, however your state calls it. Then you have your financial powers of attorney, and finally the trust. So it's those 5 things. Now I'll talk about the will first. So the will is a legal document that, yes, identifies things like, what property you want to leave to whom and, who you want to name as executor. But it also says things like, who's going to be your child's guardian. Now, when I'm speaking to clients about a will, I like to bring up the fact, I know I think I'm cheeky, but I like to bring up the fact that, I don't want the state to choose what color to paint the road, let alone who should be raising my children. That is, if I had any. But a lot of people don't know or understand that if there's no will in place, you die in something called intestate, which just means that you die without a will. And so what happens then is that the state law decides things for you. They decide things about your children because your children become wards of the state. And then it is the legal obligation of the state to vet your family members to see if they're quote unquote acceptable to take care of your kids. Now, I don't know about you, but I wouldn't want any children of mine to have to go through the system until family was vetted, right? Especially after just losing their parents. I'd do anything I could to prevent that situation from occurring. And not only that, the state might not even pick the same relative I would to raise my kids. Maybe I'd want it to be my sister Melanie and they picked my sister Rochelle. I don't know. Neither of my sisters will feel bad that I called them out like that. But, they might have a different outcome than the one that I wanted. So whenever I talk about wills, I do always mention the children, but I also always bring up a client of mine, Karen, because something happened to Karen that it just so eye-opening. And I asked her if I could share her story. And she said yes. So Karen came to me later on in her life. She was, in her late 60s, but Karen was married for 35 years to her husband. And they were in a loving and devoted marriage. And, they no point thought that they were, hurting each other, but they thought they were doing the right thing. And what they did was they went and got a will online. They did the cost-effective method, the do-it-yourself method. So they thought they had everything settled because they're like, oh, we need a will. Boom, we got a will. Well, with these online fill-in-the-blank forms, it doesn't come with any professional advice. So you're not really 100% sure that you've done everything correctly, right? And I don't know about you, a legalese is kind of, confusing to understand. So we make mistakes sometimes. And that's what happened with Karen and her husband. In his will, he wrote everything to Karen, right? He loved her. They had this great marriage. But what he didn't know was that any account that he had with a named beneficiary, as an example, his 401k, well, that named beneficiary would supersede the will. So it was a huge shock for Karen when her husband died and all of his 401k assets, they were earmarked for his ex-wife, who he was only married to for 2 years.
Oh my
with Karen,
God.
35 years with his ex-wife, only 2 years.
Oh my gosh, that's so terrible. Yeah, that's very important.
If they had worked with a professional, they would have been told that, but they didn't. They did the online thing. And so isn't that an awful thing to happen? That's why I always say it doesn't cost money to work with a professional. It pays, right? They help you do things correctly. And they also help you design the best estate plan for you, right? They have that experience. They're doing it day in, day out. They've seen things that you haven't even considered, and they're able to help you. They know the things that should be covered in your will, and they make sure they're there. And then the things that don't even need to be in your will, well, they don't put them in there, right? So we'll come back to that when we talk about trust, but let's stay on topic for wills right now. The next portion of the estate plan is something called the living will. Chris, why don't you tell us about living wills?
Sure. You know what? I'm going to talk about the next two just because they kind of go hand in hand. The living will is what is going to inform your doctors and your loved ones what your preferences are when it comes to your medical treatment and the care that you would like to have when you can't speak. Living wills typically are just their instructions that are regarding your life-sustaining measures, organ donations, pain management, as well as other healthcare wishes. So let's just say that you've been battling with a debilitating disease and you're tired of fighting, but you might update your living will to include a DNR, which means do not resuscitate. You might decide that after 30 days, you don't want to be kept on machines. And these are all the kind of medical decisions that you can make when you have this living will. And you're doing this when you're sound of mind, when you can still speak, when you can still talk for yourself. And doing this it's good because you're not leaving these kind of decisions to your loved ones. I mean, who wants to make that kind of decision when you're already stressed out because the person is having a hard time? Let's see, the healthcare proxy. If you haven't heard of that, we're going to, it has different names like Stephanie mentioned. In different states, they call it something different. But this basically is going to name someone to make the decisions for you if you can't make the decisions for yourself. And let's see, this person is also going to name and enforce the wishes that are in the living will. And if you don't have these documents, this is sad because the doctors are going to just follow state-defined course of action. And that may not be what you wanted. And you don't want your family to have to fight over this. It's stressful enough without having to fight over these types of decisions. And actually, this just happened to one of my friends. It was hard to see because they didn't have all this stuff in writing. And now the siblings didn't agree on what they did with their mother. So help them out. Help them by making their decisions and desires known now so that they don't have to do what my friend's family just went through. And there is something else you should know. Some states recognize just one document, and that's called the Advance Directive, which is the durable power of attorney, aka healthcare proxy, which I just mentioned, and the living will combined. And you need to know that some states require that you complete both documents, both the healthcare document and the other document, the other will, so you just need to find out what your state says you need and make sure to check again if you ever move to another state.
Yeah, great point. It's very state specific. So you really want to go and see what your state needs. Laws do change per state. And so, yeah, there's some that are ubiquitous to all the states, but yeah, be very specific to your state. And Chris, you just moved. So there's a very good point there, right? Moving is a trigger to go relook at your estate documents. I mean, any life change really, but you're right in the midst of all of that. So that's probably something that you're doing, right?
Right. I just moved from Georgia to Florida, and there are so many things that need to be updated. And I'm so thankful that I have a team of professionals that are working for me. And, all the T's are crossed and the I's are dotted, or else, I feel like I have so many irons in the fire, I guess. It's nice to have somebody that knows what's going on and how to make sure it's happening properly.
Yeah, it's great to have that team behind you working with you to keep everything aligned. And like I mentioned earlier, working with professionals doesn't cost you money. It pays for itself in benefits. All right. So looking at our list, we talked about the first three docs. Now we have the fourth. And it's another power of attorney. There was that healthcare power of attorney that you were just talking about, the medical proxy. But another popular one is the financial power of attorney. The financial POA is a legal document which you and you're called the principal, grant the authority to act as an agent, which is known as the attorney in fact about, financial matters.
Yeah, actually, there's 6 POAs. There is the durable power of attorney, the non-durable power of attorney, general powers of attorney, limited powers of attorney, springing powers of attorney, and medical powers of attorney. And this is all stuff that we need help with. I mean, who knows what all of those power of attorneys are, unless you have someone that understands this. So one thing you need to know, a lot of people think that automatically what they have is going to go to their spouse. And I remember, Stephanie, you telling me about one of your clients this has happened to. Do you mind sharing that with the listeners?
Yeah, sure. So your spouse is not automatically your power of attorney and things. That is a great point. So I shared with you the story of Marianne, and I'll share it here too. So Marianne and her husband lived in Miami, and she was a client of mine when back in the day when I lived in Miami, and they didn't have a power of attorney for each other. They thought, being a married couple, I mean, she could speak on behalf of her husband. They were equally owned everything. And it was all good. And while everything was good, it was good, right? Until something happened. So Mary Ann's husband traveled quite a bit, especially to Jacksonville. And during one of his work trips, he was severely injured in an automobile accident. He fell into a coma. And what Marianne started doing was, of course, wanting to be near her husband. She would travel back and forth from Miami to Jacksonville so she could go, be there near him because she missed him. But this was obviously very expensive. She was taking time off, the cost of going and coming. So she decided that she was going to sell the house, resign from her job down in Miami, and just move up to Jacksonville, find a new job, get a new place, and, be near her husband. Right? I mean, they loved each other. That's what she wanted to do. And it made 100% sense. So that's what she started to do. And that's when the headache started for her. She was listed on the house as owner with her husband. And they both had to sign to put up the house for sale. Right? She did not have power of attorney to sign on his behalf. Now, before I go any further, I would like to say that this is not necessarily a bad thing. I mean, could you imagine your spouse went and sold the house behind your back without you knowing? That'd be awful, right? So I'm not saying that this is not a good thing that both parties need to sign if in case something happens, or I guess, if you're selling your house. But in this instance, when something happened to him, she was in a bind. Obviously, he couldn't sign since he was in a coma, and she couldn't sign without him. Well, long story short, with the decrease in income, all her new expenses, Mary Ann ended up losing her home to foreclosure. She just couldn't make ends meet by herself. It was a really, really sad situation. And I always think about her when I think about the importance of having a power of attorney. You want to be able to have somebody, be you. And in the instance you can't. Not when you're fine and you're walking around, but in the instance that you can't.
Wow. And that all happened just because they didn't have their power of attorney set up. That's a horrible happen to anybody. I feel bad for your.
Yeah, it is. Right. Yeah, no, it's awful. And powers of attorney, they're just so important because you want to have the ability, to have someone act on your behalf. Maybe you're out of the country. Maybe, maybe it's not so dire as the coma, but maybe you're just out of the country and your car gets towed and you want somebody to pick it up from the towing company, right? You need a power of attorney for them to do that. So there are a lot of different reasons why we should have one, but I digress. Another very important thing is the last portion of our segment today, which are trusts. Chris, you're so knowledgeable in trust, so why don't you go ahead and tell us about them and how they help us out?
Okay. When we're talking about estate planning, we're talking about protection. We always talk about protecting our clients from the 5 enemies of wealth, which are inflation, market fluctuation, devastation, taxation, and litigation. And did you know that trust will help you with taxation and litigation? I know you can write your own wishes when it comes to your will, but what a will does not protect you from is probate and estate taxes. I don't know if you know anybody that's went through probate, but it's not really a pretty picture. We all know about Prince, We've all heard about Prince. He went through probate for 6 years. Well, he didn't go through probate. After he passed away, his family went through probate for 6 years. His estate went through probate. And when you have a will, all you have is a will. You have an executor, and that person is going to be responsible for filing the will with the probate court. And different states have different rules for timeframes. Usually the minimum is like 6 months, but filing is what gets the probate started. It gets the probate process started. And this probate process is it is intense. I mean, and the poor person, I mean, I never will actually want to be the executor of anybody's will, because there is so much that has to be done by that one person. And then plus the court has to make sure that the will is authentic. And I mean, I don't know how they figure that out, but they're the ones that decide if it's authentic or not, and if it's valid, and if it's going to be accepted as a true last testament of the person that has passed away. They're also going to be the one that appoints the executor named on the will. And this is going to give the executor the legal power to act on behalf of the person that passed away. And during this time it's when wills can be contested, which, like I mentioned before, this is exactly what happened with Prince's estate. And there were so many legal fees, really hefty legal fees, and everything was public record. And if you don't want everything public record, you don't want to just have a will. Most of us want to keep what we have and who we've owed private. We don't really want that out there to be public for anybody to find out. Plus, this also opens the door to people that know what our beneficiaries are going to get. And that can open them up for litigation, especially, when people see money, sometimes they get sue happy, especially in the sue happy state of California. It doesn't protect your beneficiaries from having to pay estate taxes. And a trust can allow for transfer of assets both discreetly and estate tax free.
I definitely don't want part of what I'm leaving to my family to be paid out in legal fees or estate taxes. But here would be a good time to talk about what is and what is not included in the probate process, therefore letting our listeners know what should be placed in a trust. Can you tell us about that, Chris?
Well, whatever kind of assets that you have, if you're not putting in trust, they're going to go through probate. And that's anything like your furniture, any heirlooms that you might have, personal possessions, bank accounts, investment accounts, and vehicles, real estate. Any of those are examples of assets that need to be put into a trust.
Okay, great. Those are all examples of things that go through probate. So you mentioned investment accounts, but it's not all investment accounts, right? Retirement accounts allow you to name a beneficiary, which trumps the will and doesn't go through probate. And they don't go into trust because they're not probated. So it just kind of allows for an easy payout when you pass away, kind of like life insurance, right?
You're exactly right. But we're not going to get into the life insurance part right now. Just make sure that you have your beneficiaries listed, because I want to talk to you about ways that you can avoid probate and avoid all of those costly fees and taxes. And these are some of the steps that you can take to avoid this. Like I mentioned just a second ago, proper beneficiary designation. Make sure you list the person that's going to be the beneficiary. And if you get remarried, you don't want to end up like Stephanie's client and end up with nothing because your husband or your partner forgot to switch who the beneficiary is. And I mean, that was a horrible story, but I just make sure that if you get remarried, you change that. And the next thing I want to talk about is payable on death and transfer on death designations. If you have any accounts like the bank accounts, like Stephanie was talking about, or your IRAs, you need to have a POD arrangement. And this is so easy to do. All you need to do is just ask for a form. It's free. The beneficiary becomes the account holder upon death, no probate. Okay. It's also called, maybe you've heard of it, Totten Trust. the TOD is similar to a POD, but you use it with investment accounts like 401ks, IRAs, brokerage accounts, stocks, and bonds. And some states actually allow you to use it on vehicles and real estate, but not all states. So you definitely want to look into this first, because these designations are going to be more precedence over your will. Also, this is another one. Any assets that you have that are held jointly also will skip probate. There's a few different types. One is a JTWROS. I love all the jargon. Tenancy by the entirety, tenancy in common, and community property. This could be a total topic for another podcast. And the reason I say that is because I personally do not think this is the best thing to do. And I know we can't go into detail right now, but I would love to be able to talk about why. I personally don't think what I've seen and studied and seen with other people, I don't think this is the best way to go. And then the last thing is, like I mentioned, a trust. You need to have these items that could possibly go through probate in a trust. And there's two different types of trust. There is a revocable trust and an irrevocable trust. And then there is hybrid trust that I absolutely love because it gives you the best of both worlds. And I'm going to tell you about that a little bit. The safeguard trust is irrevocable, but I'm going to tell you why that's a good thing and why the hybrid works, because typically irrevocable trusts are not the best type of trust and they're not suggested a lot of times. However, this hybrid trust, it protects your family, you, from litigation, and it also protects you from long-term care as we get older. And they're amendable. That's one of the benefits of the revocable. And this is why I'm calling it hybrid, because if most irrevocables are not amendable. And they also have a stepped up basis, which is for taxes. And this is another topic for another podcast. Stepped up basis, people don't understand what that is. Just know it's a tax benefit. It's a way to help you save money in taxes. And this is also a great benefit from the revocable trust. The grantor can be the trustee, which is something that comes with a revocable trust, not typically with an irrevocable trust. You can spend the principal, which is something that you can do in a revocable and not an irrevocable. Grantor trust, you don't have to go get a whole new EIN number, which is what you normally have to do with an irrevocable trust. And the best part, the reason why I love this trust, is the asset protection. Any revocable trust that you have does not have asset protection. The only thing that it's keeping you from is going through probate, keeping your family through probate. But if you own anything that you could be sued, you need to have one of these type of trusts that will keep your assets away from the lawyers. And the only three times that somebody might consider having a standard irrevocable trust is when they want to minimize estate taxes, become eligible for government programs, and then they want to protect their assets from creditors. And this particular safeguard trust that we have, it's amazing because you get to check off all three of those. I know I kind of babbled on about that. And if you have questions, anybody has any questions, please just reach out to us, because I would love to have a conversation with anybody about, protecting their family with a trust.
Yeah, that's great, Chris. And it really is, like you said, a great thing because, there are those 3 times where irrevocable trusts are better than the revocable trust. But with this hybrid, you check off all of those 3 times. So you get all the benefits of the revocable, but also for those 3 instances in life, like you're protected. So that's great. Yeah. If anybody has any questions about that, definitely reach out to Chris, because she's just a wealth of knowledge. Now, unfortunately, we are out of time, but I learned a lot. Chris, you shared so much, but I know there's so much more. So next time we're going to come back and talk more about trusts, but we want to know before we start recording, do you guys have any questions? If so, we definitely want to hear from you. What did you still have some questions on based on what we talked about today. What do you wish you knew more about? If you leave us a 5-star review on Apple Podcasts, we'll see it, and just type in the question in the review section and we will reply in our next podcast. Or you could leave a message on our Facebook page. And again, in our next podcast, we will answer all of your questions.
All right. Well, that wraps us up for this week. Thank you so much for tuning in. Join us in our Facebook group, CashFlow Hacks, and follow our Facebook page, CQ Consulting Services, Chris Quintana if you want, and our YouTube channel, Instagram page, LinkedIn, and Twitter. We're out there.
Financially Sassy Woman. That's our YouTube channel.
Oh, yes. And subscribe. Give us a like. Thumbs up. Remember, sharing is caring. Who do you know that needs this information? Thank you so much for listening. We'll be back next week with more details on trust and how they uniquely can protect you. And see you next week.